afternoon, everyone, and welcome to our pre-sale lunchtime seminar today. I'm delighted to introduce Robert Hingley, and Robert has got a long and extremely illustrious CV, which I'm not going to do justice to, I'm afraid. Robert was, contrary to what I've said in the bio that I've circulated, Robert no longer works at Ondra, but in fact he's a non-executive director for a number of companies and other organisations at the moment. And notably, Robert is also a member of the UK Takeover Panel. He's currently a member of the Code Committee, and previously he's also served as Director General of the Takeover Panel, in particular at the time of the Cadbury takeover. So he has very much been at the very front line of UK takeover regulation at the highest level, working with what was I believe the biggest hostile takeover of recent years anyway. So he's certainly got a lot of stories to tell us from that walk of life. Robert has also had a very extensive career in investment banking. He started his investment banking career with Schroders in the mid-1980s after a brief spell in legal practice. Robert spent 18 years with Schroders and also worked with Citigroup, including as their head of the Global Financial Institutions Group and also the head of German investment banking. In 2005, Robert joined Lexicon Partners as vice chairman, and in 2010 he joined Lazard as managing director in its financial advisory business. Then in 2012 he became Director of Investment Affairs at the Association of British Insurers. So that's just a glimmer of Robert's career. There's so much more stuff I could probably tell you, but he's done a lot. He's got a very varied background and he's got lots to tell us, most notably including about his work with the Takeover Panel just now. Hence the title of Robert's talk today, The Takeover Code in its wider regulatory and political context. So, Robert.
Great. Thank you, Mark, and thank you very much all for coming this afternoon. I realise you have other and more important things to do. I was going to talk a bit today not about the details of the rules of the Takeover Code, but how the panel operates, why it operates as it does, and also to touch a bit on how political considerations are beginning to encroach on its traditional remit and arguably pose some threats to the way that it operates. I wasn't proposing to go through the rules in any details. I have included some materials in the handout which touch on some of the major rules. I'm very happy to answer any questions about those, but I thought it might be more interesting to give a rather wider view rather than just sort of plough through the rules endlessly, which I'm sure other people will do at a later stage. So, background on how the panel operates. The panel has been going for just under 50 years, and it is important to notice that for most of its life it has operated on a purely voluntary basis. It has had statutory backing since 2006 following its takeover directive and is now the designated authority to regulate the conduct of takeovers in the UK. But its roots are very much in the sort of the voluntary structure that it had at the outset. The way that it's set up is that it's always headed up by an investment banker on secondment, usually for a period of 2 years, who's the Director General. And the theory is, and I think it's a good theory, is that if you have somebody who comes from current practice, then they are able to take commercially sensible decisions and indeed to know when the investment bankers who appear and lawyers who appear before them are telling the truth or when they're just trying to pull a fast one. But it does mean that it's a commercially sensitive regulator. Beneath the DG, there is our 3 permanent deputy DGs. The current ones have been there between 10 and 30 years, so there is a huge wealth of experience with them. And then, in a tier below them, the people who deal with calls day to day will tend to be a mixture of some permanent ones and then secondees from major law firms, banks, brokers, accountants, people who want to be able to acquire some experience of the code. The way that it operates is highly, highly unusual. I think it's pretty much unique in the world. And if it didn't exist in its current form, I think it would be, in current circumstances, very difficult to create it. It hands out rulings on the way in which the code is to be applied in particular circumstances. And if people breach the rules of the code, then the sanctions that it has available to it are, on the face of it, pretty feeble. That you can issue a private letter of censure. So you send a stiff letter to the bank or whoever has been naughty and say you've been very, very bad, don't do it again. If it's worse, then they can get publicly criticised. And there have been 3 cases of what is known as cold shouldering, when somebody has been sufficiently bad that the facilities of the London market are withdrawn from them. So, and the FCA will support that, but it means then that they can no longer really operate in the London market. That has happened only on 3 occasions, once in 1992, once in 2010, and once last year. But those things remain very, very rare. You have to quite try hard to do that. So you could say, well, why do people bother? I mean, if you're just going to get publicly criticised and there are billions of pounds worth at stake, then so what? And the answer is it works because it works, that it is integral to the way that the city has operated now for 50 years. People believe that the integrity of the market is upheld by the Takeover Panel, and so therefore it is really important that those rules are adhered to. And I believe it is still the case that in many banks, that if you are responsible for some action that has led to your institution being privately criticised, let alone anything else, that can be terminal in terms of your career. You can be fired for that. There is an appeals system if you don't like the ruling that the executive gives you. There is a 2-stage of appeal. You can appeal to the hearings committee, which is always headed up by the current chairman of the panel, who will either be a eminent QC or a former judge. And if you don't like their ruling, then you can appeal to the appeals board, which is an independent body which is headed up by some combination of a former law lord and or a former Court of Appeal judge. It is subject to judicial review, and there are 2 cases that, if you're interested, you might want to have a look at. One is DataFin in 1987, in which, even though it hasn't got a statutory, or had not then a statutory basis, it was held that judicial review did apply. The lead judgment went out of its way to say that the courts would. It was almost inconceivable the courts would interfere in what the panel did. And that was reinforced by the Expro case in 2008, where there was a scheme of arrangement. 2 shareholders wanted to challenge the timetable ruling that the panel had given out, and were effectively trying to use court procedure to get round the rulings of the Takeover Panel. And the judge went out of his way to say that court procedure should not be used to create a level of uncertainty that the code provisions had already reduced or eliminated. In other words, the code or panel decision should provide sufficient certainty to steer an offer process in ordinary circumstances without the need of court intervention. So the courts have very much butted out of this. And I think given that the appeal process you would have to go through before judicial review involves at least 2 former judges and probably 3, that the chances of proving that this was a decision that no reasonable regulator could have taken are quite low. So judicial review is not something that people worry very much. There is a power of enforcement of certain rulings which has come into place since the Takeover Directive came into place. Those have been used only once. In fact, that's going on at the moment. There was an order for somebody to make a mandatory offer for Rangers Football Club, which the person has consistently refused to do, and that is going through the Scottish courts at the moment. So very briefly, the great advantages of it is that it's a flexible and market-sensitive regulator. It is within the Director General's gift to disapply rules in certain circumstances, and there is quite a wide range of discretion, and people like that because it means that the way that the regulator operates takes account of the commercial realities. The disadvantage is that sometimes there is a body of practice where everybody is supposed to know that, even though it's not written down, and of course everybody doesn't always know that. So people do complain sometimes that there is a lack of certainty of rulings, but I think overall that it is held in very high regard, and as I said, it works because it works. And if that market confidence were to be damaged, then the whole system could unravel quite quickly, I think. So The Takeover Panel arguably is only as good as its recent rulings, and as long as its recent rulings have remain consistently fair and commercially sensitive, then its reputation remains very high and it continues to be in a virtuous circle. But that would be possible to change. There's quite a lot of wording on this page, and this is one I'm going to leave most of it for you to deal with later. But as I was indicating around the flexibility a moment ago, the spirit and not just the letter of the rules is what is important here. And there are 6 general principles which, if you're looking at the code at all, I would really, really encourage you to read, because they are used an awful lot. And broadly it is the case that all the detailed rules are an expression of one or more of the general principles. So very briefly, the first general principle is that all shareholders of the same class should be treated equally, and all general principles are equal, but if one is more equal than others, it is that one. That is an absolute guiding light of the way that the panel operates. Shareholders should have sufficient time and information to make a properly informed decision about a bid. The target board must act in the best interests of the company as a whole and not deny the opportunity to shareholders to consider a bid, and that's important, I'll come back to that. False markets or distortions in the share price should be avoided. If somebody is offering cash consideration, that cash has to be available at the time that the announcement of a firm intention to make an offer is made. And finally, that the target should not be inhibited in the conduct of its affairs for longer than is strictly necessary. And upon that last one, an increasing amount of rules and practice are now hinging. I won't go through the stuff on the right. It is important just to note that the moment when an offer is effectively, there is a contractual commitment on the behalf of the offeror to make a bid, is at the moment of a firm intention to make an offer, what is known as the 2.7 announcement, where you get all the detail of what the consideration is and the conditions. The conditions that are written in the back of any takeover offer are, in many cases, close to useless, because it is very, very difficult to invoke them, and that is within the gift of the takeover panel. And there's an important case in 2001, just after 9/11, where somebody tried to invoke material adverse change because of the impact of 9/11, and the takeover panel, and this went all the way through the appeals, said no, you've still got to go ahead with your offer. So if 9/11 is not enough to trigger material adverse change, it's difficult to know what is. So effectively, those conditions that you all read and may lovingly write in the back are close to useless. So a bidder is really, really committed at the time that it makes its firm intention to announce an offer. So let me, having done that all quite rapidly, let me pause a bit about the context and the way in which it operates. The first 2 bullets I've put out here are taken directly from the code, so there's nothing original in those wordings. That wording. I mean, the code is there, the panel is there, really to protect the interests of the shareholders in the target company. That is what it is primarily set up to do, and it is quite overt about this. And most of the rulings, when you're working at the takeover panel, if you're asked to make a ruling about something, the first question you will tend to ask yourself is, what is in the interests of the target shareholders? It has also been axiomatic, and it's actually written in the general principle, that it is generally in shareholders' interests to have the opportunity to consider a bid, and then the process follows from that. But the mindset of the way that the code is set up is they're there to look after target shareholders, and target shareholders should have an opportunity to consider a bid and then decide on it. And as we'll see, that life has been moving a bit away from that particular set of principles, and that is causing, I think, some political difficulty for the takeover panel. The thing that the code is not concerned with, it's not concerned about financial or commercial advantages of takeovers. It has no view about whether it is a good thing or a bad thing for a particular company to be taken over. That is for the shareholders and other regulators to decide. So what it does is to work with the other major regulators, particularly the FCA and the Competition Commission, so that they can do their job within the context of the Takeover Panel rules, the Takeover Code rules. So of particular interest to the FCA are leaks and false markets. And I've put quite a lot in the back about what happens if there is a leak and who has to do what and in what order. If you are ever in practice about this stuff, you will spend more time worrying about Rule 2 and leak announcements than almost anything else. And the Takeover Code or the Takeover Panel has really come down on this in recent years with the encouragement of the FCA, so that leaks, an announcement will follow a leak very, very quickly indeed. And the basis of that is then that if there is an announcement that something is going on, then the market is properly informed and people can trade freely. It's when there is rumour or speculation that something might be going on and the market has not been informed of that, that is when a false market can occur. In terms of competition, there is a long-standing rule that if there is a Phase 2 CMA reference, or these days a Phase 2 European Commission proceedings are instigated, then broadly speaking, the offer automatically lapses, and then the timetable stops and people can then start again once that those proceedings have been dealt with. One of the things that the panel is considering at the moment is, well, what happens about Phase 2 European Commission proceedings after Brexit? Whether to keep that, whether to extend it, or whether to go back to a more narrow UK definition, and that's something that will be dealt with in the next year or so. So, how has all that been affected over the years? I wanted to refer to three important cases, a couple of which go back to the 1980s. Guinness Distillers, I suspect you may have heard or come across. This was absolutely at the forefront of aggressive takeovers, shareholder value driven takeovers in the 1980s. There was a competitive bid for Distillers. Distillers had most of, or a lot of, the famous gin and whiskey brands, which are now part of Diageo. So Gordon's, Dewar's, Johnny Walker, those sort of things. Guinness had for a long time been a sleepy Irish company that made nothing but Guinness. Guinness, I have to say, in the early 1980s was not trendy at all. And Guinness was resuscitated, revolutionised by the chief executive called Ernest Saunders, who then made an aggressive bid for Distillers in competition with a bid from another company called Argyll, which has long since gone away. It was all it was stuff of soap operas, really. It ended up with a number of people going to prison. There was an illegal share support operation, by which I mean that Guinness had offered for shares, a share consideration for Distillers. So the value of the offer was critically dependent on the value of Guinness shares. And what Guinness did, it organised what was called a fan club to buy Guinness shares in the market and so support the Guinness share price. That of itself would not be arguably too bad. What made it very, very bad indeed was that Guinness gave an unlimited guarantee to each of those people buying shares in the market against losses that they might incur, which crashes through a large number of provisions of the Companies Act. This case was really, really damaging for the panel because it all got, really fairly hideously out of control. And I think people started to question at that time whether the panel was actually adequate to be able to deal with takeovers and that sort of behaviour. And certainly the criminal case was very important. It did, and it continues to frame thinking a lot today. Acting in concert is another major part of what the panel does. So people coming together with a view to taking over control of a company. And it is very, very easy to be considered to be acting in concert. Any arrangement, formal or informal, will do, and the panel spends a lot of time policing that. That is perhaps not what I really want to focus on today, because one of the other things that actually where it started to unravel, as part of its offer, Guinness said, we will move our head office to Scotland, Distillers being a largely Scottish-based company because of the whiskey, and we will appoint a man called Sir Thomas Risk as our new chairman. And Sir Thomas Risk was a very eminent member of the board of Bank of Scotland and pillar of Scottish society. And once the offer had been successfully completed, they decided that perhaps they wouldn't do that after all. So they kept the head office in London and told Thomas Frisk that his services were no longer required. And it was the investigation into that which started to uncover some of the other things that had been going on. And that led to a long-standing practice, if it wasn't entrenched before, it certainly was after Guinness, of an unwritten seventh general principle that you are held to what you say. So that if you say something in the context of a takeover bid, to do with whatever, if it's important to shareholders, if it's important to the overall conduct of the bid, you are held to that. And I think that was absolutely an excellent principle. And that has been tried to be reinforced, but arguably I think made it less good. I'll come on to that in a second. Rowntree, I put there because nothing happened, actually. Rowntree was very, very similar to Cadbury's. Rowntree was a famous chocolate company in York, had Quaker origins, did all the same things that Cadbury did around being, by certainly Victorian standards, extremely philanthropic towards its staff, staff housing, a very, very morally run company. Rowntree owned things like Kit Kat, so it was absolutely central to people's imagination. Chocolate companies, people can get to understand. GKN, building aircraft wings, rather less so. But chocolate companies, everybody gets. So it's not, I think, wholly coincidental that a lot of the investigations into the panel or into the way that the code works, have come from chocolate companies. All the same thing, Nestle, nasty foreign company, we don't like that, so we should look at the way that the takeover code works to protect British industry. And in 1988, when shareholder value, shareholder considerations, basically capitalist considerations were very much to the fore, virtually nothing happened. They made a couple of insignificant and soon rapidly forgotten changes, but really, for all the furore that happened at the time, nothing happened. Very different 20 years later with Cadbury. So Cadbury was arguably not a British company at all. I think something like 10 to 20% of its turnover and profits and staff were in the UK. It had made a number of ill-considered expansions overseas, particularly into the US. It had been pretty badly run for a number of years, share price performance poor, returns on capital poor. It had done some restructuring. It used to own the Schweppes brands. Those had been sold off, but arguably it was a company sitting there saying, please take us over because we hadn't run our business very well. And Kraft duly came over the horizon. And Cadbury, I think, fairly shamelessly wrapped itself in the Union Jack flag and made a point about the Quaker origins and Bourneville and the heritage, the British heritage of Cadbury, and there was even stuff about, well, these horrible Americans are going to change the recipe of Cadbury's dairy milk, which many might say would be a good thing, but that was sort of used as part of the emotional argument for it. And that was all fine. It all went through, there was a lot of publicity about it, but it all went through fine, and everybody seemed to think that this had gone pretty well, until there was a meeting between the chief executive of Kraft, Irene Rosenfeld, and the then Deputy Prime Minister, Lord Mandelson, at which Kraft reiterated to Lord Mandelson a promise they had previously made to keep some factories of Cadbury's in Bristol open, which Cadbury's had previously announced it was going to close down. And it didn't help, apparently, that Irene Rosenfeld and Lord Mandelson hated each other on sight. But about a week later, Lord Mandelson, having then trumpeted this, is that we've done a great thing in the context of this takeover, that we have protected British jobs, that Kraft turned around and said, well, we've had a look and perhaps we've seen that Cadbury are right and it's not really feasible to maintain this factory being open. And they changed their mind. And Mandelson threw a serious tantrum about this, was very unhappy and wanted to know what the Takeover Panel was going to do about this. And this prompted the major review that then took place in the course of 2010-11. The announcement, if you look at it, of the review specifically refers to Lord Mandelson and that taking account of the concerns that the Secretary of State has raised, which is okay in terms of the panel. because it's always open to receive sensible suggestions how to change the rules. Who more sensible than the Deputy Prime Minister, so that's all fine. But the political will for something to be done was very strong at the time. Some quite significant changes were put through during the course of 2011, quite deliberately to change the balance of the rules in favour of the target. The most important, I think, are really the put up and shut up stuff. That there is now a fixed period of 28 days after something leaks. The bidder must be named, and then they have 28 days in which to put forward a firm offer, and that period can only be extended, and this is the fundamental change, only be extended if the target agrees. Previously, you ended up with sort of 6 to 8 weeks, and it was always in that period, so the time period doesn't matter so much. But it was not previously in the gift of the target for the period to be extended or not, and that has really made a difference. Some other things which I've listed there are perhaps less important, but you can see that the whole shift was around making it more difficult for an offeror. So things like the elimination of deal protection and inducement fees, a lot of which, following American practice, had come in, and lots more emphasis given to the interests of employees and the wider intentions of the offeror. And I think generally those changes have worked well. But the pendulum has continued to shift in that direction. So the next major one was the introduction of post-offer undertakings following the Pfizer or proposed bid for AstraZeneca 4 years ago. Pfizer wanted to take over AstraZeneca. AstraZeneca has, as you may know, a major research facility in Cambridge. It is central to the UK drug industry. It came out of ICI and a series of following motors, but a really, really important company. And as part of this, Vince Cable, who was then the Secretary of State at the time, was very concerned that jobs should be protected, that the research and development shouldn't just go all go off to the United States or somewhere else. So the Chief Executive of Pfizer, talking to the government, made a 5-year commitment to complete AstraZeneca's new research centre in Cambridge, to retain a manufacturing facility in Northern England, and to have at least, I think, 15% of research staff in the UK. But Parliament got very excited about this because they were concerned that there was no mechanism to enforce these undertakings. And there is a letter written by the chairman of the Science and Technology Committee to David Willits, who was the relevant minister, saying it was unclear that the government could hold Pfizer to these promises, and that some of the assurances were a bit vague. So they wanted them more precise, and they wanted a mechanism to enforce it. And following that, again, a degree of pressure, parliamentary pressure or political pressure applied to the code to change its rules, which they did. And you now have a 2-tier structure. You can have statements of intention which have to be validly based at the time you make them, but you're not held to them in the same way. And formal post-offer undertakings to which you are held and which the Takeover Panel is responsible for policing. And written reports have to be made. The Takeover Panel can appoint a monitor to check whether the offeror is who's made these undertakings, fulfilling them, and formal reports have to be made public. You could say, and I think I would say, that this stuff is nothing to do with the Takeover Panel or the Takeover Code. If the Takeover Code is there to regulate the conduct of offers, then this is going way beyond its traditional remit, and it is arguably the sort of stuff that they are not particularly well set up to look at. But that is their responsibility now. I think it was also thought that because the post-offer undertakings were so onerous and such a high level of scrutiny, that no sane person would ever actually give any. And there is one example of them actually having been given, which the government was very, very excited indeed about, which was SoftBank and Arm Holdings in 2016, which was announced very, very soon after the Brexit vote, and when there were a high degree of concerns that research and development, all technological expertise would leave the UK. And so that there are some very, very wide commitments by SoftBank to double the number of employee headcount, UK headcount of ARM in the UK, increase the number of employees of ARM outside the UK, and keep ARM's headquarters in the UK for at least 5 years. So the Takeover Panel is now in the process still of reviewing those undertakings, and there is no reason to suppose they won't be adhered to, but the Takeover Panel now has that responsibility for doing that. I think the thinking is still that it is very unlikely that people will make these binding undertakings as a matter of course. Statement of intention's fine, but you could then say, and I think I probably would say, that the impact of this is actually to reduce the level to which people making those statements of intent are held. Because if it's just if it's just a statement of intention, then you can say that circumstances have changed and therefore I'm not going to do it and it's all a bit unfortunate, but there you are. So if you go back to the two earlier cases of Sir Thomas Risk and the Bristol factory of Cadbury, difficult to know exactly, but if those had just been statements of intention, it is at least arguable that the bidder would have been held to those less than they were in fact held at the time when the regime was more informal. So what has been designed to make it more binding, or to have a mechanism for more binding, has arguably weakened, at least to some extent, the effectiveness of the policing of those statements of intention. There are still concerns about whether the playing field is tilted too much in favour of the offeror. Some rule changes went through in the back end of last year, most of which are not hugely significant, but the government was very interested in them because they had made manifesto commitments to this effect. The most important of which is now that if you are subject to a hostile offer, then normally after the date that the offer document is published, you have 14 days to issue a defence document. A well-prepared offeror will issue the offer document almost at the same time as it's making its first public statement that it's going to make an offer, so that they follow almost on the same day. 2 weeks, not very long. So there's now that the target can say that there is the earliest possible date at which the offer document can be published is after 14 days, so they can have a month. That does give the target more time, and that is the major change. But I think that the wider point here is that there has been quite a different shift in philosophy compared with the late 1980s between the interests of, or whether it is viewed as politically the right thing to do for shareholders to have shareholder interest to have primacy, or whether other things have become more and more important. And in a wider sense, after the 1970s, there was definitely a shift in the argument between who gets labour or capital gets the rewards from industry, definite shift in favour of capital. There is arguably a secular shift going in the other direction at the moment, and that is beginning to influence the way in which the Takeover Panel operates. So in that context, I just thought I'd touch briefly on Melrose and GKN, which is an absolute classic, in many ways, 1980s style takeover. Melrose comes out of Hanson Trust. Hanson Trust was a company that did a series of takeovers in the 1980s about unlocking shareholder value in sleepy companies. And the chairman of Melrose used to work for Hanson Trust. GKN, if you look at it, it has underperformed for years. Its capital has been poorly invested. Its returns have been pretty poor. Its returns on capital have been poor. Its shareholder price performance has been very weak, and it is not projected to grow anytime soon. So it is, in those sort of 1980s terms, sitting there, having underperformed. Arguably, it was always going to be susceptible to a bid. And they have admitted themselves that this has taken place. They've changed the chief executive. They are expected to announce this week they're going to sell off part of the business with a view to releasing shareholder value. You may have seen that this has engendered calls from both the Labour Party and from the Liberal Democrats for it to be blocked. The mechanics for that are far from clear. There are, I think, 4 grounds beyond competition on which you can block takeovers in the UK: national security, media plurality, broadcasting standards, and financial services. You might be able to get GKN on national security because they make aircraft wings. Others would be better position to know whether that is the case or not. I would have thought it's pretty spurious. It is more likely that it may be blocked in the US because of security type issues, because a lot of GKN's business is now in the US around aircraft wings. It has changed that, again, like Cadbury, it has 60,000 employees, of which only 10% are in the UK, so it's arguably not really a UK company anymore. But there is the possibility that politically it will not be capable of being blocked in the UK, but it might be blocked in the US. And I can see that if that were to happen, that the US were to block it, then people will say, well, why? It's a UK company. Why couldn't we block it here? Something must be done. And I think it's an interesting example of what happens on that bid as to whether the debate moves, that people really are not comfortable with that sort of degree of sort of laissez-faire, that the government does not have a public interest test that it can apply. And historically they have fought shy of that. But that's going to be a very interesting thing. The defence document, I think, is due out tomorrow or Thursday, so worth watching if you're interested. So finally, all that says, I think, is that because of the shift in wider political attitudes and people's concerns, the panel is being drawn into areas beyond its traditional remit. I don't think that the whole thing about post-offer undertakings is necessarily a good thing. The panel is absolutely, it's there, they can't change it, they will do it, but it's arguably outside what they are really about, if you think back to what I was saying at the beginning. I think there are concerns that the politicians want the takeover panel to do things for which the takeover panel is not set up, and they have been reluctant to introduce a wider public interest test to date, not least because then they are seen to be the people who are responsible for blocking something, and that causes other issues, and they don't like it. So the Conservatives have definitely been reluctant. I think the other two parties probably would, and certainly Labour would if they had a chance. It is critical, in my view, that the independence and the integrity of the panel is maintained. The panel has sole responsibility for changing its own rules. If the politicians start to interfere with this, then the system, which I think has served the UK market very, very well for a large number of years, will start to come under threat, and that would be a great pity. I'm sorry, I've counted through that really quite fast, but I was asked to leave time for some questions, so very happy to take anything that arises from that. There is some stuff on the more detailed rules in the back. Again, if there's anything arising out of that you'd like to talk about, then please let me know.